Hi, I'm Jessica Hanslechuk-Treadwell with the Wichita Foundation. Welcome to our Professional Advisor Series, where we meet with members of our Plan Giving Council. These are experts that we know, we work with, and truly trust. These are folks helping people every day navigate their decisions about finances, their legacy, and their community impact. Our hope is that these short conversations are helpful for fund holders, donors, nonprofits, and anyone thinking about how to give well now and in the future. Today's topic, in honor of Make a Will Month, is Estate Planning 101, and I'm joined with Ryan Farley, who's a trust and estate attorney here at Hinkle Law Firm, who's going to walk us through what we need to know. Welcome, Ryan.
Thank you for having me.
Thank you so much for joining us. So what happens in Kansas if someone passes away without their will in place?
Sure. It depends on a couple of different factors. First factor is going to be how an asset is owned. Assets that are owned joint with right of survivorship automatically pass to the surviving joint owner at the death of the first owner. Or if there's a beneficiary designation through, like on a 401k, life insurance, those designated beneficiaries receive those assets upon the death of the insured, if we're talking about a life insurance policy. The default under state law covers what happens if you have an asset that's in your individual name, an asset that's not owned jointly with somebody else, and an asset that doesn't have a beneficiary designation on it. If you are married and you don't have children, the asset passes to your spouse. If you are married and have children, half of the asset goes to spouse, half of the asset gets divided amongst your children in equal shares. If you're just single and don't have children, it goes back up to your parents. So depending on what your family situation is, it's going to depend on how those assets are distributed. And in blended family situations, that can create some additional complexity.
I can imagine, yeah. What are the most common misconceptions that you hear about, setting up your estate plans?
Probably the biggest one that I run into on a regular basis, and given that it's Make a Will Month, is that many people think that once they've made a will, that they don't have to go through the probate process. And probate is just simply the court identifying your assets, identifying your creditors, identifying your beneficiaries, and then applying the rules that apply to make sure that those people are taken care of. In the case of a will, the will is overriding state law, those defaults that we talked about a minute ago, in terms of who's going to receive the assets. And so the will has to go before the court, be approved by the court, and then the court works with the executor to supervise that administration. Many people that I've run into over the years come into me more than 6 months after somebody has died and say that they are working to take care of mom's estate. They were named in the will to be the executor, and it's never interesting unless somebody's getting left out. Inevitably, that's when this comes up, and unfortunately, if a will is not submitted for probate within 6 months of date of death, it's invalid. We can't use it. And so having that conversation when somebody thought that they were receiving all of their assets and that their deadbeat brother or some other relation was not going to get anything, and having to tell them, no, this person is now entitled to some of these assets, can be challenging conversations.
Wow. So how long, once it's in probate, within that 6 months, does it usually take?
It can take anywhere from 6 months to a year, depending on the complexity of the assets, when the probate process is started, how many people are involved, how many creditors are involved. But as a general rule, usually no more than a year on most estates.
So I'm getting close to that big 5-0 number. When should someone start thinking about getting their estate plans in order?
Most of the people that I deal with are going to be in a range. Most of the time we do estate plans or do real basic wills when we first have kids to identify who might take care of our kids if something were to happen to us while our children were still minors. But it's a process. It's intended to be something that you revisit on a regular basis. And so, you may start with a real basic estate plan when you're first married, when you first start having children, but then as you progress in life and your career and you accumulate wealth and life changes, there are going to be updates that are needed to the estate plan. So it's something that, one, every adult should do. but also something that you should do on a somewhat regular basis. At a minimum, look at what the estate plan says and make sure it's still doing what you want it to do.
What's the best way to include charitable giving in your estate plans?
Like many other parts of the estate planning process, the best way to include charity is to be proactive and intentional. You want to choose to plan your estate plan, not let those defaults that are in state law control. The defaults that are in state law don't include charity. And so if you have regularly given to your church, local community organizations, the Wichita Foundation, those charities that you've been supporting over the years are not automatically going to be included in your estate plan. And so first off, look at your assets. Look at the assets that you intend to leave to your beneficiaries. Look at your total estate and look at your prior giving history. How much of that do you want to leave? There are certain assets that are better for charitable giving than others. For example, with a traditional IRA, that's a tax-deferred retirement plan, which means that income tax is going to get paid on that when money comes out, either when you withdraw it or when your beneficiaries withdraw it. But if you've left those assets to a qualifying charity, they won't pay tax on it. And so it's a way to benefit both the charity and your other beneficiaries who won't then have to pay income taxes when they receive that IRA or withdraw the money from the IRA or 401k.
But there are other ways to support the family where they wouldn't have taxes to take out.
Correct. So in a normal circumstance, if you bought Apple stock at $100 and you die when the stock has a value of $200, if your beneficiaries turn around and sell that stock immediately after your death, they're really not going to pay any gain because they get a step up in income tax basis on the stock from the $100 to the $200 at your date of death. And so some of those assets have been in the family for many years. Farm ground, for example, that's been purchased early in life and is held for many decades, don't have those basis adjustments on a regular basis. And it can be very difficult for family members to sell that in retirement versus if they receive it after an inheritance to be able to turn those assets into dollars.
What are the advantages of working with a community foundation in your estate plans?
One of the things about working with a community foundation is that as we age, as our lives change, our charitable interests change. We may have focused on particular charities younger in life, and then as we age, as our kids are involved with different things, as we become involved in different community organizations, those interests also change. When you do an estate plan, you have a very formal document if you're using a will, or you have maybe a revocable trust that you might use as your primary estate planning document. Those typically require some additional steps to modify and change over time. Working with a community foundation, you can develop a planned giving strategy working with people at the community foundation, and that's easier to change over time as your interests change, as the community changes, as the needs of the community change. So that's one way that the community foundation can make it easier as part of your estate plan to make those charitable gifts. Additionally, working with the community foundation helps establish what your intent is for your charitable giving during your lifetime so that the community foundation can help provide that guidance, help provide documentation for that legacy. So after your death, your beneficiaries can work with the community foundation to carry that out.
Thank you so much, Ryan. That was incredibly helpful. We hope this conversation answered some questions that you might have had and sparked some new ideas and gave you helpful next steps to think about. If you have any questions or want to learn more about the Wichita Foundation and how we can support you, feel free to reach out. If you found this useful, please feel free to share it with anyone. And again, thank you, Ryan, so much for joining us.
Thank you for having me.
Thanks.